tonight's webinar, which is the first webinar in our new series, IP for the People. Tonight's webinar, Getting Started with Intellectual Property, or IP for short, explains what the types of IP rights are and provides real-world examples of how these rights come up in your day-to-day business and creative processes. After the overview, we will interview an author to hear how she learned about IP law and how it has helped her. And then we'll take some time to answer your specific questions. But go ahead and put them in the chat box whenever you think of them. We'll be monitoring the chat throughout the night, and we'll save your questions for the Q&A portion at the end. After the webinar, we will email you a copy of today's slides so you'll have them. Now, I'll turn the program over to our Wikimedia Race and Knowledge Equity Fellow, Shriyanka Merchandani Chengara.
Hi, everyone. I'm so happy to be here today to see the Institute in action, doing what they do best, which is empowering everyone by making intellectual property accessible and just a little less daunting. As Tasha said, my name is Shriyanka, and I am the Wikimedia Race and Knowledge Equity Fellow for this academic year. This is a research fellowship designed to explore the intersection of racial equity, free knowledge, and intellectual property. In other words, the very purpose of this fellowship and my role in it is to find ways that intellectual property can become more inclusive, equitable, and accessible to everyone, but especially for the communities that have historically been marginalized, underserved, or overlooked when it comes to reaping the benefits of intellectual property. So the underlying goal is really to find ways to open up the IP ecosystem and to empower everyone to capitalize on it, basically. So that is, in short, what I will be doing. It'll involve a lot of research, writing, and advocacy, and I'll be working with the Institute and Howard University during the fellowship. If you have any questions about it, feel free to reach out. But for now, we'll get right into it with a presentation on what exactly IP is. And for that, we have Professor Latif Matima. I'm sure some of you already know Professor Matima well, but for those who haven't made his acquaintance, he is the founder and director of the Institute and a professor of law at Howard University School of Law, where he teaches intellectual property. With that, I'd like to hand it over to Professor Matima, and I will also be sharing my screen with you for the slides. Give me a second. Okay. Professor Matima, please.
Okay. I had to make certain that I unmuted myself. You would think that at this point in the pandemic that doing Zoom would be second nature, but I have a good excuse. I just literally ran over. If you were watching the screen, you see me taking my jacket off. We just did something of a similar program, but not as detailed as we're going to have a chance to do for you who are attending this program this evening. So one of the things that we do at the Institute for Intellectual Property and Social Justice, as both Tasha and Shriyanka have pointed out, is that our reason for being is to make certain that everyone in society has access to and an understanding of and receives the benefits from the IP system, with a special emphasis on communities and groups and cohorts that have been traditionally not only underserved by the IP system, but oftentimes exploited by the IP system. And the idea is to restructure that relationship. And the significance of restructuring that relationship really needs to be understood, because it is not simply improving the role and the benefits that new participants will receive from being engaged in the IP ecosystem. It is a beneficial relationship that goes two ways. When everyone in society is participating in intellectual property production, creation, dissemination, and usage, society as a whole benefits. The more intellectual property that is produced, the more intellectual property people are exposed to and inspired by. If those people who have been excluded from the IP system are now a part of the IP system, it gives them the opportunity to think, to imagine, to create, to produce, to develop, to disseminate, to share. And not only will they benefit from this, but society will benefit from this as a whole. In the other program that I just left, which was a community outreach gathering of our one of our other programs, Take Creative Control. And Take Creative Control, we go out into communities, we bring together groups. This was a group of people who are, some of them were musicians, some were fashion designers, some were painters, and we had a wonderful setup. We had the paintings and photographs of different artists, and they were there for sale, right? And this is the way you want the IP ecosystem to be presented to people, right? As an exciting, fun, engaging opportunity, right? And one of the things that I said during the presentation was that, you know, IP, when it comes to IP production, here in the US, we have the potential to continue to do what we have always done, and that is to lead the world in IP production. And why is that? That's because in the United States, this is the most diverse nation on the planet. And if you have the most diverse group, it means we will have the widest and broadest range of ideas, okay? There's no idea that a human being can come up with that could not come out of the United States, because in the United States, we have every type of person, okay? So with that, what we want to do this evening is to just prepare for you and present to you a quick overview of what intellectual property is. What are the various types of intellectual property? And you should just relax and listen and enjoy this. We're going to do this in about maybe say the first 15, 20 minutes, and then we're going to move on to an even more important part of the program, where we're going to have an opportunity to speak with somebody who's just like you, doesn't do IP for a living, produced some IP, and then went out and started taking the steps to protect and exploit it and make money from it, right? So the first thing we're going to do is to let everybody else get up to speed. I'm going to go through what the different types of IP are, what steps you pursue to protect it, how you can go about and then exploiting it and commercializing it. And one of the things that I think you're all going to be surprised at is that you all already have IP. You just don't know it. You will know it by the time we get to the end of this presentation. And as Tasha pointed out, don't worry about taking notes and all that sort of stuff. You can if something strikes you, but we're going to provide you with these slides after the fact, okay? So we start out with what is intellectual property. That's our first slide. And I think, yes, go to the next. The 5 types of intellectual property. You see them right there. The first 2, trade secrets and patents, what the focus of those types of intellectual property protection are directed towards, they are encouraging human beings to engage in, to create, to produce useful types of IP, useful inventions and innovations that do things. Machines, a new type of machine. Formulas, a new formula for curing headaches, right? Vaccines. Here's a great one, a useful type of IP that you all have, trade secret. A trade secret can extend to something that is useful but as simple as a recipe, okay? So trade secrets and patents, they address useful forms of intellectual achievement. Then comes copyrights. Copyrights focuses on expressive forms of intellectual achievement. By that we mean books, movies, songs. Basically, we want you to use your mind and soul and heart to figure out what's the best way to express something? What's the most effective way to get this idea across, right? What is an artistic way, an informational way? But oftentimes the value is not in the information, but how the information is expressed. And if you meet the requirements for copyright protection, then the form of IP protection you get will be that of copyright. The last two are trademarks and publicity rights. Trademark is basically how you put your brand on what you do. There will be other people who will be doing some of the same things. They will be selling the same kind of product or providing the same type of service, but they don't do it the way that you do. And when you put your brand on it, you put your mark on it, this is the way that you make certain that when people have been exposed to your wonderful product, man, that was the best set of pancakes I ever had. You don't want them rolling up in some other place and saying, I'd like some of them really, really good pancakes. And then they give you somebody else's pancakes and you eat and say, I will never eat a pancake again. What you don't know, right, is that you didn't want any old pancake. You wanted some of them Fatima pancakes. That's where trademarks come in. And then lastly, publicity rights, which is my favorite because we all have them. Publicity rights are the way in which you protect your image, your likeness, attributes of yourself to make sure that other people don't use those things. They don't use your name or your photograph in order to promote their services or sell their goods. Hey, like we say, if you like it so much, put a ring on it. Hey, if you like my image so much and it's going to help to sell your products, okay, license my publicity right. So already right there, we have an overview of the 5. And now what we're going to do is we're going to go through each one in just a couple of minutes so that you understand what does it take to get this type of protection. Once you have that type of protection, what kind of rights you get with it, how you can use those rights to protect your work, make money off of your work. And at the end, we will have all 5 covered. And I promise you, you will see that you have at least one of these types of IP. Most of you will have at least 3, okay? And then some of you will see immediately how, wait a minute, I think I want to get some of the others because I got something sitting in my file drawer. Okay, next slide. Okay, so what is a trade secret? A trade secret is, as the slide says, all it has to be is information that most people don't know, something secret that is valuable. You can use it in a business that will give you an advantage over others, right? To qualify, it just has to be that. Commercially or economically valuable, secret, or known only to a limited number of people. And here's the trick. You have to take reasonable steps to keep it confidential. You can't blurt it out to other people, right? I've got a great example of that, but let's go to the next slide first. Okay, so here are examples of formulas and recipes and things that are protected as trade secrets, and I'm sure you recognize some of them. A lot of people don't know that the formula for Coca-Cola, it is protected as a trade secret. Hey, those special secret herbs and spices in that chicken, Kentucky Fried Chicken, protected as a trade secret. My favorite one is up there near on the top left-hand side of the screen, at least from my side looking at it, DC sweet potato cake. DC sweet potato cake is such a wonderful example because it was started by a brother who was basically selling sweet potato out of the back of his car, sweet potato cakes out of the back of his car. How he started doing that was that he knew his mother made the best sweet potato cake. And he called up his mother and said, Ma, because you know he said it that way, right? He said, Ma, can you send me that recipe? Because I know people would love to have this, right? He didn't have a store or anything, and he started selling them. He meets this woman who is an African-American attorney who is specializing in business law, not even IP, but she had enough exposure to know, I think you have something there that should be protected as IP. Long story short, does the research, finds out, yes, what you have, it's information, people don't know it, it is of value, it can be used in a business, and here's come the clicker. I hope you ain't told a whole lot of people. He had not. And because he had not, boom, there they are in business. They're able to get venture capital investment because they know other people are not going to be able to knock off your sweet potato recipe. He went from selling it in his car. People in DC know this. You go into Starbucks, you see DC sweet potato cake. You go into Wegmans, gigantic, everybody out here knows, a lot of people in the country know what it is. DC sweet, it is now a multi-million-dollar business. So those of you watching this, yeah, go in the kitchen, find them recipes. You have IP, and you can skip the selling out of the back of the car stop, right? You can go right ahead. Wonderful example of trade secret. Next slide. Okay, how do you protect it? Well, this you already know. You got to keep it secret. Here's the bottom of the slide deals with an interesting challenge. Okay, if I got to keep it secret, now my business is getting bigger, right? I'm DC Sweet Potato Cake. I ain't got time to be making the cake myself, right? You hire employees. I have to tell them. Does that mean I lose my trade secret? No, you do something called a non-disclosure agreement. It is not that fancy, right? You could write out, take a piece of paper, write out your employee, let's say your employee's name is Latif, right? Because you better write an agreement with me, right? Because otherwise I'm gonna take it, right? Latif, I'm gonna share the recipe with you. You can only use it in this business to benefit me. That's why I'm telling you the recipe. Go in the kitchen, make it up, I'm paying you your salary. You cannot use it for yourself. You cannot tell anybody else. If you do, you will be violating my trade secret right. See, that easy. You just have to take reasonable steps to protect it. Hide it in the file drawer, lock and key. Major corporations, they keep it in the vault. But an everyday person, all you have to do, put it in your drawer, and if you have to tell an employee, just have them, what I just said, that one sentence, have them sign it. You're good to go. Next slide. If you have a trade secret, meaning it's not well known, you take the necessary steps, what do you get? Well, the right that you get is protection from misappropriation. You get protection from people getting your trade secret in an improper way. So if people do any of these types of things, they break into your back office, they lie to you to get it from them, or hey, look at that last one, right? They violate the non-disclosure agreement. Employee runs out and he starts making his own sweet potato and selling it out of the back of his car. Oh, wait, violation of that's what you get protection against, right? Have a trade secret. I'm protected against anybody using my trade secret in any of these kinds of ways. Next. Okay, so we already have one area of trade secret under our belts, and most of us know that we already have these. Next one is patents. Patents are, let's just sort of say, trade secret 2.0. First, patent also covers useful innovations, useful inventions. In addition, patents are a little bit harder to get because they are more complex, they are bigger, they are a bigger leap, right? It's not just something simple. So in order to get a patent, what you're doing, just like a trade secret, it has to be useful, but it also has to have these other characteristics. First, it has to be what we call patentable subject matter. Fancy word for saying it has to be one of these four things. Your invention has to be a machine, or it could be a compound, could be a chemical compound, or it could be different things you find and mash together, right? Can be an article of manufacture. That's like something you produce out of a machine, like a shoe, right? A shoe is a useful, right? Covers your feet, right? Or some sort of a process or a method, like a chemical formula, right? So like the formula for the COVID vaccine. So it's just got to fit into one of those four categories. Next, it has to be what we call novel and non-obvious. All that really means is that it has to be something that if we look at what's already out there, you made a machine, you look at all the machines that are out there, nobody has done a machine like that before, right? You've come up with a formula for treating COVID. We look at the other formulas, nobody has come with that before. In addition, if your formula is different from everybody else's, but it's close to something that's out there, you just made a little tweak, you did a tweak that would be an obvious thing to do. We say, no, that's also not good enough. Example I like to give is that what if I come up with a machine that grinds peppercorns into smaller little chips? You know, put that on your salad. Somebody looks at that and says, hey, those chips, they're still kind of big, right? So you say, okay, you know what I'm going to do? I'm going to add to the gears that grind it. When it goes into this tube, and at the end of that tube, I'll put little tiny smaller grinds. So now the flakes get in that, and now it grinds it even more fine into like a powder. Okay, but that's an obvious thing to do, right? Big grinds will make medium flakes. The medium flakes go into smaller grinds, and it comes out into a little powder, right? Okay, and so if you're just basically knocking off something that already, a machine that's already there, that's not going to satisfy non-obviousness. And the last one, enablement, it just means that when you go to the patent office, you got to give all the details. You got to lay out exactly how this works, right? Because the other reason why patents are so much more important is that society will not only get the product, they're not only going to get the machine or the vaccine, they're going to get the learning. They're going to get the information. They can study the patent and say, oh, wow, I see how you did that. Now I'm going to go off in another direction and do something else. Okay, so those are what you have to satisfy. It's got to be useful, got to fit it into patentable subject matter, one of the four. It's got to be new and not obvious. And finally, you got to give the patent office all of the details. If you do that, you now qualify for patent protection. Next slide. Okay, so here are some, familiar examples of patents, the kinds of things that you would expect. Microwave oven. I'm old enough to remember when we didn't have that. Okay, light bulb. No, I'm not old enough to remember when we didn't have light bulbs or the telephone. Okay, the cell phone, but we had, I wasn't around when Edison was around. So these are some good examples. All these things are useful. They do things. And at the time that they were invented, they were new. Nobody had done this before, right? And you see how it fits into patentable subject matter. Okay, next slide. So you go to the patent office. This is really the only one of the 5 areas of IP in which you must go through some sort of application registration process. Notice I didn't mention that at all in terms of trade secret. That's why I say you all already have trade secrets. Just keep it a secret. Once you show the patent office that your invention satisfies those elements that I described, you will get a patent, and it generally lasts for 20 years. Now that you have your patent, what do you get? You get rights that are even broader than the trade secret rights. You have the exclusive right to make, use, or sell the invention. Anybody who does any of those things with the invention without your permission, you can sue them for patent infringement. That's how you make your money. Somebody comes along, they love the way that the machine works. Hey, I can make 1,000 of them for you every month and sell them all over the country. Yes, you can make my invention. Pay me. Give me a royalty off of every machine that you produce. That's how you use your patent rights to make money. Next. Now we come to copyrights. 2 down, 3 to go. Copyrights, as I said, we're trying to encourage you to engage in expressive or artistic endeavor. We want you to take information and knowledge, wisdom, facts, figure out a way to express it, to say it in ways that will help people to get it, right? And we do that. Sometimes we do that through novels. Sometimes we do that through poems. Sometimes we do that through paintings, photographs, right? One that I like, we do that very much in many communities through sermons. All of these things are creative ways of putting information together to get the point across more effectively, bring people along, educate people, expand our culture. Next slide. All wonderful examples of copyrights. You see books, you see paintings. Hey, look at the ones down at the bottom, the Obama, right? You see, we are saying things about Obama in the photograph, and then we're saying different things in the Hope painting, right? Both are images of him, but you see how each one expresses different aspects of what we want to say about him, or about his potential, or about his impact on our society. Okay, next one. Okay, now, You engage in some expressive endeavor, a poem, you take a photograph, you write a story. What does it have to have? First, it has to be creative. That just means your own personal choices. You use your imagination. You don't just say, hey, he got up and fell. No, you say, I want to convey that to you. He rose mightily, much like the redwood in California. Then, as if struck by some celestial assaulter from behind, he teetered and thundered down upon the ground. You see how I've expressed the same information. In the first time, I didn't do it with any creativity. No value in that. But I put my spin on it, okay? And that's what made it creative. Second thing, it has to be original. Really simple. I didn't copy it from somebody else. That's it. If both of us come up with the same thing at the same time, coincidentally, we are both original. You just have not to have copied it, right? Creative, original, and finally fixed. Write it down, put it on paper, put it on tape, put it on film. Those three things, that's it. That's all you have to do. Like I said, with patents, you have to go through the registration procedure. Here you don't. Registration is optional, very simple, easy to do. We're going to talk about that a little bit later. And if you do it, it gives you certain extra rights, like you can bring a case in court, et cetera, et cetera. But the minute you fix your work on paper, tape, et cetera, boom, you have copyright protection. Next slide. When you get your copyright, these are some of the rights that you get. No one else can make a copy of the work without your permission. No one else can distribute the work without your permission. No one else can make a derivative version. For example, I write a story, you want to turn it into a movie. That's not a copy, that's a derivative work. You want to make a movie of my book, get permission. I'll give you the derivative work right, you give me a royalty. You see, this is how you see, we go through this over and over again. What does it take to get a copyright? To get whatever IP it is? Now you've got that type of IP, what kind of rights you get? These are the rights once you get copyright protection. Once you have a copyright, look at how long it lasts. It lasts for the life of the author plus 70 years. You will have this right not only till you die, but 70 years after you die. You have something to leave to your heirs, right? The great Bill Winters passed recently. They are still paying money to his estate, okay? So all you young folks out there, tell your parents to do some copyright, okay? So those royalties will keep coming in many, 70 years after they're gone, okay? And just like all the other areas of IP, anyone who engages in any of your exclusive rights without permission, you can sue them, right? Trade secret, if somebody engages in misappropriation, they get and use your information improperly, you can sue them. Patents, anybody makes, uses, or sells your invention without your permission, you can sue them. Copyright, anybody who engages in any of these rights we've listed above, they make a copy, they distribute it, they create a derivative work, you can sue them. We all have copyrights, because anytime you write anything down, anytime you try to figure out, I want to say it this way, again, automatically, it's creative. You didn't copy it from anybody else. You've put it down on paper. You've recorded it on tape or on film. You automatically have a copyright, and you don't even have to go to the Copyright Office and register it. But as you'll see later on, there can be some benefits to going ahead and doing registration. Next. Trademarks. We already got 3 down. We only got 2 left to go. Trademark is what you do when you want to put your brand on something. Whatever it is that you make, whatever service it is that you provide. Trademarks are, as it said there, word, symbol, color, phrase. You can do anything, right? It could be a drawing. You could say, okay, I'm selling shoes. I want to sell monkey shoes. And you draw a little monkey, right? And if people like your shoes, they come back to the store and they say, you know what, I really like these shoes. What, is it brown, is it black? They were them monkey shoes, automatically, okay? So somebody may come up with a shoe that looks like your shoe, and the person getting ready to buy it, they say, but wait, where's the monkey symbol? And that's how you know, right? Because you put a little something extra in your shoe, people want your shoe. They don't want a brown shoe like your shoe, they want monkey shoes, okay? That's what trademark's all about. Next slide. Okay, examples of trademarks. Again, all these are nice and familiar. You've seen these brands. Nike is not the only company that makes a sneaker, right? Adidas, they're not the only ones who make a sneaker. But when you go to the store, you'll say, no, I don't want just any old sneaker. I want a Nike sneaker. I want an Adidas sneaker. Look at the one up on the top. Once again, DC sweet potato cake. You see how what they've done? First, they get the IP. Now they distinguish their sweet potato cake in the marketplace. So that if somebody had a great tasty, oh, I love that sweet potato cake, they go back to the store, they say, I want some more sweet potato cake. This is how you can make certain that they don't hand you somebody else sweet potato cake. Because I guarantee you back there, they got something that's called Matima sweet potato cake. And I'm just hoping that by mistake, they give you that so I can finally make a sale, right? The trademark is how we distinguish the good sweet potato cake from the crap that I'm making there in the back room, okay? Okay, next slide. Okay, what do you need to do to get a trademark? You see how, once again, it's always the same thing. Hey, I like this type of IP. This will be helpful to me. What do I have to do to get it? First, you choose a mark, a symbol, a word, a phrase, a drawing, whatever the case may be. It simply has to be what we call distinctive. It just means it has to be something that you're thinking about the mark and not the product. So obviously you can't use a shoe if you're selling shoes. They're not gonna know what the hell you're talking about, right? I want shoes. Wait, you want one shoe or two shoes? That, we call that generic. That doesn't help, right? It doesn't distinguish your shoes from other shoes, right? Descriptive, also that doesn't work. I want brown shoes. Okay, again, it's obvious what the problem is, right? We need something that when a person says, I'm looking for gorilla shoes, we know you're not looking for shoes, you're looking for a particular brand, right? And that's what distinctiveness is, right? The mark that you choose, the word, the symbol, the color, whatever it is, it has nothing to do with the product. It is so far away from the product itself that we know, oh, okay, you're not asking for shoes, you're not asking for bananas, you're not asking for any old sweet potato cake. You're looking for a particular brand, okay? And marks that are so far away, we call them fanciful or arbitrary, or marks that are, if you really, really think about it, you might see a connection. We call those suggestive. Those two types, fanciful or arbitrary or suggestive, words, phrases, things have nothing to do with the product at all. Okay, so that when you ask for that, people know you're not asking for that type of item, you're asking for a particular brand. Once you have something that is distinctive, that fits those two categories, then you just have to actually use it in business. That's it. Pick a distinctive mark, start using it, start selling it out of the back of your car or whatever. Now you qualify for a trademark. You do not have to go through the registration process. Like copyright, you can do that. And if you do it, it can provide you with some additional benefits. But automatically, you see how easy it is to have IP, right? Some of you get ready, wait, don't leave just yet. Some of you heard all this, getting ready to run out. The offices are closed. You could wait till the end of this presentation and tomorrow go out, lock down your IP. Next slide. Okay, once you have the mark, what do you get? And you see how everything that's here I already told you, right? Yeah, you could go get registration, apply to the USPTO office. They're very helpful. They'll walk you through the different possibilities. You can prevent others from using your mark or a similar mark because people would be confused and they'll say, I want gorilla. Is that, looks like the monkey, right? So you're the only one who can use it. And if somebody tries to use your mark on their shoes or tries to use a mark that looks like yours, you can sue them for trademark infringement and not only receive damages, but also prevent them from continuing to do that. Next. 4 down, 1 to go. Look at that. You are all about to be IP experts, right? In like 20 minutes. Yeah, man, you're gonna brag to all your friends tomorrow. Publicity rights. This simply, as I said, it protects people, whether you're famous or not, from other people making commercial use of your name, likeness, or recognizable attribute. Sometimes they may not be using your exact photo, but they may be using things that people know it's you. For those of you who are old enough to remember good times or see it on the reruns, what if I did a drawing of a skinny black man in one of those denim hats saying, "Dynamite"? We know who that is, right? We know you're trying to pretend that Jimmy J.J. Walker is endorsing your product, right? And the thing of it is sometimes people will buy something not because they necessarily think the product is great. They haven't even tried it yet, but they say, "Oh yeah, if that person uses it, I want some," right? Can anybody say Beyonce? Right? Is that the perfume Beyonce uses? Yes, I'm gonna buy it. Girl, you ain't even smelt it yet. Listen, let me tell you, I ain't got to smell Beyonce. I know she smelled fine, right? Okay. Sometimes people are gonna want to use your image, even if you're not a famous person. I had a student tell me once some years ago in the middle of class, "Professor, I'm not famous, but I saw my face on somebody's website." What were they selling? They were selling educational loan services. "We'll help you get your loan and blah, blah, blah. We'll do the paperwork for you." They were targeting minority students. They saw her picture somewhere on the internet, she looked lovely, hair in a bun, horn-rimmed glasses. Yes, we want to put that on our website. Why? Because people will see that. Students will see that. Students of color will look at that and say, "Well, if that's the type of person that they service, I think I would like them to service me too, because I'm like her. Look at her. She looks so smart and successful. Of course she's going to be." Hey, if you like my look, like I said, put a ring on it. Come to me, say, "I want to use your photograph, pay me," right? And that's what Publicity Rights enables you to do. All you have to do is to be a person, okay? And you automatically have publicity rights. Next slide. Here are all examples of people. These people, most of these people were chosen because they're famous. But some of these people aren't famous. If they are, I've just outed myself that, I'm an old man. I don't know who some of these people are. But the two models, I don't know that they're famous. They just like their look, right? People look at that and say, "Yeah, I'm going to buy what they got, the makeup they got, because I'm going to look like that." You wish. But nonetheless, right? Okay, the image, the reputation, the look, these are things that can help move products. If it's going to move the product for you, you're going to make some money off of it, fine, I'm happy to help. Just pay me. Okay? You all got publicity rights, right? Because you all look so lovely. Next slide. No registration process, once again, and if anybody uses your name, image, likeness, or what have you, you can sue them for misappropriation. Same thing like infringement. I don't know why sometimes we use the word misappropriation if it's trade secret or publicity rights, and then other times we use the word infringement if it's patents, copyrights, or trademark. It's the same thing, right? You can protect your rights by bringing a lawsuit. Next one. Look at that. Now we're going to send you this. See, so I know you were mesmerized by all the stuff that I said so fast and what have you, and I try to be charming when I do it, but you don't have to worry about taking notes and all that kind of stuff. Here are links that you can go to get, the additional stuff you need, more education, more detail. How do I go ahead, go through the registration process, all there for you. And I think, next slide. Oh, see, the next slide should be me taking, a bow, thanking you all. So that's it. You're now IP experts. And once you get the material, we send it to you. Now you're totally fine. I'm going to hand it back to Shriyanka for the most important part of our webinar this evening.
Thank you, Professor Matima. For this portion of today's presentation, we're going to be speaking with Nadia Griffith Allen. She's going to tell us a little bit more about how intellectual property has been useful to her in her endeavors. Nadia is an educator, a disability advocate, a certified wellness consultant, and an author. She has a bachelor's degree from Syracuse University, a master's degree from Columbia University, and has worked in education for over 20 years. So welcome, Nadia. Why don't you start off by telling us a little bit about yourself, what you do?
Good evening. Thank you, Shreyanka. Yes, I work for a college in New York City where I am the director of the Office of Accessibility Services, as well as the director of the Children's Center Services. Somehow I managed to marry my two degrees, one being in elementary education and the other one being in higher and adult education. I'm the mother of two gifted sons by the name of Garfield and Garvey, and I am an author.
Okay, so you don't work in the field of IP.
No, I do not. I've always remained in the field of education.
So how did you come to be involved with IP?
I didn't know it at the time, but I became involved through my desire to write my children's book.
That's cool. What made you want to write a children's book? Did you enjoy writing it?
Yes, definitely. I can say the first reason was obviously my love of teaching, the fact that I am an educator. I taught education for several years in the elementary school system. And through doing that, I saw that reading was the first step. And for me, when I had my two sons, I decided that to build a strong foundation for them, I had to make sure that they knew how to read before they entered their educational journey. And with that, I decided that teaching them how to read was very important, and that some of the skills and techniques that I provided them, that others definitely could benefit. Also, at the time, I have a good colleague and friend by the name of Laquan Johnson, who is an author. And he shared with me that he had just finished writing his first book and he was working on his second book. And of course, I was like, you can write a book? That's amazing. How do you even begin? Where do you even begin? And I said, I always wanted to write a book. And he shared with me that I should. He asked me, what did you want your book to be about? And I told him, teaching children how to read. He definitely encouraged me because prior to that, he had used some of my techniques that I shared with him, and he used it to help teach his eldest daughter how to read. And he told me that she then taught her little sister how to read based on some of the tools and the resources and even the games that I provided him, which is in my book. And Laquan Johnson also provided a testimonial in my book. So with learning all of that, I knew that this was something that I needed to do.
So how did you discover the connection between your project and intellectual property?
I didn't know it at the time, but through wanting to write my book, but also through attending a lot of the webinars similar to the one tonight, programs such as Creative Control, that I learned that through all of this information that the Institute provided to me, that I could protect my work by a copyright. And then I also learned that if I developed or created several copies, that I could get a trademark.
Did you move on to then applying for copyright registration for your work?
No, not right away. First, I wanted to finish the book. At that point, I also wanted to give the book some life. I wanted to bring it to life. So I decided to have illustrations, and I called upon my best friend. It's always good to have a best friend who, no matter what crazy idea you come up with, he will agree to be a part of that. And my friend, Antonio Cabanez, is actually the illustrator of my book. And then I decided to reach back to my friend Laquan Johnson and to ask him, where do I go next? And he introduced me to his publisher by the name of Portia Steele from Mystique Rose Publishing Services.
Okay, so once you decided your book was ready for distribution publicly, what was your next step?
Well, my next step was to speak with the publisher and to have the publisher work with me, one from the ISBN number that's needed, next to work on the jacket, the color, to provide that second eye to edit the material. And then at that point, she was able to publish it through Amazon for me.
And was she able to help you with your copyright registration?
No, that is something I did on my own. And I can say that the process is extremely easy once you find the correct form, which the copyright.gov website, it wasn't my best friend. It wasn't easy to navigate. It was extremely difficult. And I had to call upon the Institute once again and say, which form do I use? I'm not even sure. Is it the standard? Which one? And of course, the Institute for Intellectual Property provided that information. And then I had to come back once again. I can't find the fee. And they had to help me. So I will say this, the website, not user-friendly, very difficult to navigate. But once I knew what I needed in terms of the form, I would say it took me 15 minutes or so to register for copyright. Ask simple questions, name of the book, name of the author, when was the book completed. So once you navigate through the difficult website, the registration is absolutely simple.
That's fantastic. So you did the registration all on your own?
Yes.
Yep, that's amazing. So your book is available on Amazon now. We will probably share a link with all of our attendees who are interested. This has been really inspirational. Thank you for sharing, your experience with the process and how easy it is for IP to be used by everyone. Do you have any final words of advice?
Well, I definitely would like to say that, when you have something that is passionate, you should definitely try to give it life. My book, A Child's Gift of Reading, was my passion for several reasons. It allowed me to share some of the techniques that helped me to help my children to start their educational journey. It also allowed me to create memories with my children. And that was a passion that I thought I needed to share. And I'll give a little spoiler alert. This book was definitely a labor of love for me because two of the characters in the book, if anyone decides to pick up a copy, I think you will fall in love with them. Their names are Prim and Joey. The two characters are named after my parents, Primrose and Joseph. So I definitely wanted to share all the gifts that not only I gave to my children, but was given to me when my parents helped me on my educational journey. And all of this was possible through the Institute for Intellectual Property and Social Justice, because if I did not attend the webinars, and if I didn't go to the creative control programs, I would not have known all of this could be possible and how to protect my work. And if later on to get a trademark, which I already started that. My book is it's a series called Read to Receive. And the reading part is obvious. It's the story, the reading part of the book. And two, because there are two takeaways from my books. The second part is the receive. You receive the education or the resource. So it's the Read to Receive series. I hope you enjoy them.
Thank you, Nadia. It's such an inspiration to hear about how any idea that you come up with can be protectable by copyright, by any sort of intellectual property, and what you can do with intellectual property rights. So thank you so much for joining us tonight to share how you were able to use the IP ecosystem in publishing your book. I think it looks like we have a good few minutes for a quick Q&A, if there are any in the chat. I'll hand it over to Liana now for the Q&A. Thank you.
And so while we're looking to see if we have any questions, sir, first off, Liana, do we have any questions already in the queue?
No questions.
Okay, so while we are, waiting to see if you folks, don't be bashful, ask a question if you have one. But just a couple of quick observations about Native story. So first off, obviously, we all have stuff that we can do. If it's a recipe, you can it's secret, and produce the product, start selling it out of the back of the car, and then develop a business. If you have a story you want to tell, techniques to develop yourself, things you've learned by doing your job the way that you do it, what have you. And you feel that this could be a benefit to other people. You can sit down and you can just write a book. How elaborate you want to be is totally up to you, right? She decided she wanted illustrations added to it. Apparently, she thought the way she was isn't good enough. Got somebody else to help, but again, that's all just part of your own personal choices. The decision to reach out to one of these small individual publishers, again, that's just a personal decision. I mean, once the book was written, that's it. It's creative, it's original, it's down on paper. You automatically qualify for copyright at that point in time. But if you feel like, as she said, you want a second pair of eyes, well, you can ask for a second pair of eyes. That could be one of these independent publisher outfits, or it could just be your friends and your neighbors. How does this sound to you, right? Okay, this isn't like going to one of these great big publishers. Will you, make multiple copies of my book and sell it? You can do that. You can go to one of them, if you want to, or you can just self-publish and go directly to Amazon yourself, right? But the important thing is in terms of protecting your work, owning your work, making certain that other people can't just copy it and do what they want with it because they like what you have done. And as you can see, the process for doing that, completing the book, automatically you have copyright registration. If you want some of the additional rights that you can get through copyright registration, oh, that's easy, right? The form is very easy to fill out. And what you told us about the website, yeah, that's true. I'm going to talk to the Copyright Office about that. That's one of the reasons why we have included the right link for you that will take you directly to it. But as you can see, much of the reason as to why many of us don't have IP protection, it's really two things. One, we don't know about it. And two, the challenges have nothing to do with the law itself. It's because the people whose job it is to make it accessible to us, sometimes it doesn't get done quite the way it needs to be done. And that's where various nonprofit groups and others like ours and others come in to get this feedback to the office. Because when you think about it, it's a shame, right? The form is easy. Name, who are you? Title, right? What's the book called, right? And can you imagine what a shame it is for people to get frustrated and give up before they get to that? And registration is such a simple thing to do. So I thought those were some really great insights to share with us. So we have a couple of minutes left. Leanne, anybody have any questions so far?
Not yet.
Okay, and I don't know if we took a moment to introduce you as well. We know Tasha Bunch, Program Director at the Institute for Intellectual Property and Social Justice. You got to meet Sharenka Shangaroff, who is our new Wikimedia Race and Knowledge Equity Fellow, a fellowship intended to get this type of information out to the public so that we all can become better educated and better empowered in terms of producing and controlling and protecting and commercializing our IP. And this year, we have our Wikimedia Race and Equity Fellowship intern, who is also doing double duty interning for the Institute for Intellectual Property and Social Justice, and that is Leanna Alston. Leanna, do you want to say a quick word about how did we rope you into this? What do you do? Do you have anything to do with the law or IP or what have you?
Well, Professor Matima is my professor at the Howard University School of Law. Also, yes, I'm a student. I'm a law student at Howard University School of Law in Washington, D.C. And I have a background in actually IP trial work as a paralegal. So I'm very happy to be here, excited to be doing this or looking at it from a social justice perspective.
Okay, you see why we have what I think is such a first-rate webinar program, okay? We just recruit all of the best people to help us make certain that IP functions differently in American society than it has functioned in the past. IP is not something that is intended only for the elite. It is not something that is intended only for the privileged. It's not something intended only to provide wealth and property rights to major corporations. It's intended to provide all of those things to everyday people in society. Because when you think about it, IP doesn't come from, quote, a corporation. It comes from a person's mind, right? And typically what happens is that some inventor or some author or some singer or some composer, right? They will take the IP rights that they get, the exclusive right to make, sell, or use, the exclusive right to make copies or make a derivative work of, right? And a major entity, a corporation that has the apparatus to use those rights to mass produce, they will say, okay, let me use your rights. I will produce lots of copies, and then you will get a royalty off of everything that we sell, right? And that's the way IP functions and is supposed to function. And that's the purpose that the Institute aspires to support, and what these webinars are all about, to make certain that you understand what you have, okay, what you can create, what you can produce, how you can protect it and utilize it to empower yourself and achieve whatever your goals are. Personal, inspirational, like Nadia, Griffith, Allen, or all the way to the other side, make those big bucks, whatever it is, you have that capacity to do so if you tap into your intellectual desires, gifts, and capabilities. So let's see, I think we are almost out of time. Let's check one last time, but I'm sure Leanne would have told us. Any questions? Yeah, you guys are just laying back and being like, okay, wow, I got everything I need. I gotta reflect. I gotta sit back with a glass of wine and think this stuff over. So with that, let me just turn it back over to Shriyanka and Tasha to close us out at the end of the hour.
I think, Tasha, do you have any closing remarks? Okay.
As I mentioned in the beginning, this is just the first webinar in a series, so please bookmark our webpage for details on future webinars, and I hope everyone has a wonderful night.
Okay, well, thanks everyone. Good night. We hope to see you next month at the, just before we go, Tasha, what's the title of the webinar for next month?
Next month's webinar is Patent Law for Engineers, and it will be October 25th at 7 p.m.
Okay, great. We hope everybody continues to check with our website, and also send us your email address so that you don't have to keep checking. You can get our monthly newsletter, and we will keep you apprised of not only the programs we do, but programs that other people do. We're not just trying to keep you all to ourselves. We want you to get the information that you need wherever it is available, most convenient for you, in person, online, whatever it takes. So thanks again to all of you. Thank you, Nadia Griffith Allen, for being our guest tonight. I feel like a talk show host. Thanks, Leanna Alston, for supporting us and making certain that we have everything we need. Thank you, Shriyanka Shangaroth, for being our program moderator and helping us to bring this information to the public. And of course, above all, our program director and the developer of this series, Tasha Bunch. Thanks once again. And I'm looking forward to seeing all of you guys and all of you people out there in, it's not TV land anymore, so I guess it's in webinar land, next month and in each of the months to come. Thanks again.